Hello, my name is Alma Robinson, and I am the Executive Director of California Lawyers for the Arts. CLA is a statewide nonprofit organization that was founded in 1974 to serve artists and arts organizations of all disciplines with advocacy as well as services that provide support with legal and business issues. With staffed offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego, we provide several core services. First, we provide legal counseling to specialized attorneys who provide assistance with a variety of intellectual property questions, as well as contract reviews and negotiations, and other important business issues. Depending on the client's financial status, legal assistance may be available on a pro bono or reduced fee basis. We also provide a specialized program that assists independent inventors and small startups with their patent applications. To help with situations involving disputes, we provide a range of alternative services, including negotiations counseling, mediation, and arbitration that can avoid the expense and hassle of going to court. Finally, we offer a full menu of educational programs that include workshops, symposia, and conferences on various legal topics for artists and arts organizations. Many of these programs are posted on our YouTube channel, and we encourage you to use these tools to educate yourself on the legal issues before you reach out for specialized assistance from our organization. Thank you for joining today's program, and please consider joining CLA on our website at www.calawyersforthearts.org so that we can continue to maintain our full range of services. Thank you.
Good afternoon, and thank you for joining California Lawyers for the Arts for Creative Expression Online and the First Amendment. My name is Renee Reisman, and I'm the Educational Program Coordinator for CLA in Los Angeles. So tonight we have to thank Aimée Scala, who runs her own law practice actually, and it's also Scala Law, and is also a partner is Olsoff, Cahill, and Cossu LLP. And we also have Peter Eliasberg, who at the ACLU of Southern California, who is the Chief Counsel and Manheim Family Attorney for First Amendment rights. So without further ado, I want to kind of jump into the workshop. I'm gonna now let our speakers introduce themselves. Aimée, why don't you go first and tell us who you are and your expertise?
Hi, everyone. And Renee, thank you for inviting me to participate. I'm really happy to be able to talk with the community to talk about expressive rights. It's something that I'm really interested in. So I'm a partner at Olsoff, Cahill, and Cossu LLP. We're a law firm that specializes in art law. We're based in New York and LA. And art law really touches a lot of different things. There's in terms of copyright, intellectual property matters, title disputes over ownership of works of art, auction law, museum law, deaccessioning questions. So lots of different things that touch the arts. But a primary focus of what we do is advocating for artists themselves. And that's really, where these, issues of free speech and censorship on the one hand and maybe harassment on the other come in terms of online speech. And so it's a really interesting area to talk about. And I think it's a little bit broader than the First Amendment, but I'm really excited to get into it with everyone here, and I'd love to hear from you all. So I'm looking forward to a really great conversation.
Thank you, Aimée. And Peter, why don't you introduce yourself?
Hi, everybody. I'm happy to be here. My name is Peter Eliasberg. I am the Chief Counsel at the ACLU of Southern California, and I have a mouthful of a title. In addition to that, I'm the Manheim Family Attorney for First Amendment rights. I have done a variety of different First Amendment cases over the years, running the gamut from representing members of the news media, photographers particularly, who were subject to excessive force by the LA Police Department during the 2000 Democratic Convention in Los Angeles, dating myself a little bit. I have done cases involving a very interesting case very early in my career involving an erotic art exhibition that the California Department, the liquor license license entity in the state of California tried to shut down by ignoring the First Amendment and basically saying we can kind of do whatever we want in places that have liquor licenses. And this was an erotic art exhibition that was being held in a hotel. And, I've done a variety of other kinds of First Amendment cases over the years. Just quickly, one thing I kind of wanted to clear away in terms of, I think I'm looking forward to lots of interesting questions, but sort of underbrush, because people oftentimes use the term First Amendment and free speech and censorship as some kind of interchangeable terms, and they're really not in the following sense. The First Amendment and every provision in the United States Constitution except the 13th Amendment, which prohibits slavery, only applies to the government. So you will oftentimes hear people say, oh my God, I got fired from my job at X company, which is not a government employer. And they say, they've violated my First Amendment rights. And I sort of have to gingerly say, I'm sorry, but that's actually not the case, because the First Amendment really has nothing to do with the conduct of private actors. Now, if you want to use the term censorship, I think that can be a term that's more broad than the First Amendment protections for the freedom of speech. But, and I think that there are all sorts of private entities that may try to suppress speech in a way that I'm not a big fan of, but that doesn't mean that those entities have violated the First Amendment. Now, having said that, there are a variety of statutory laws that may protect your speech and may protect a private entity, private person, company from doing things to try to restrict you from speaking. But those are laws that are going to be passed by a city council or state legislature or Congress. They're not inherent in the Constitution. So I just think that's really useful background information, because as I said, I get a lot of inquiries from people who say, well, don't I have a First Amendment right not to get fired from my job for saying X, Y, and Z? And the answer is, unless you're working for the government, no, you don't. It's just the reality of the jurisprudence. And then last thing I'll say, the First Amendment, the speech provision of it talks about Congress making no law respecting the freedom of speech, abridging the freedom of speech. Just so people know, since the Civil War, the Supreme Court has gradually said that the provisions of the Bill of Rights apply not just to the federal government, but also to local governments and state governments. So even though the First Amendment talks about what Congress can't do, if your city council passes a law that somehow or other interferes with your freedom of speech, you would just as much have a First Amendment claim as you would if it's a law that the United States Congress has passed.
A really interesting point, especially in the online context, because we're talking about almost only private actors, where we're talking about Instagram, Facebook, Google. And so in order to figure out, whether or not you have a right to, put your post back up or whatever the issue is, you need to really go to their terms of use and their community guidelines and look at those policies that they've written in order to determine what, if anything, you violated and what your recourse is. It's really not a First Amendment question so much as a policy question and set forth by that organization.
And that actually brings us to a pretty good point about First Amendment truly is a government issue, but there's also protections that apply to talking about or protesting against the government in the public sphere. So, protesting in the streets is totally protected by the First Amendment. With the online media, these are private companies, but they are public in a sense that if I go online and you don't have a private account, I can see what you write and basically anyone can see it. So could either of you touch upon this distinction about a private company, but a public platform that anyone can see?
Aimée, I can say something, and you're welcome to jump in and add or correct.
Sure, that sounds great.
But this is another, at least lawyers talk about the so-called public-private distinction. And generally, when they say that, their public is meant to be government, not generally open to the public. Now, that doesn't mean that every time the lawyer uses the phrase public, they mean the government. But sort of this phrase, the public-private distinction, is meant to separate governmental actors from private non-governmental actors. But Renee, in the example you're talking about, is it a public platform? Meaning, is it a Facebook page that doesn't have some sort of terms where you have to special membership where you have to apply to get in, and there's a moderator who says, we're not letting people in unless they meet the following criteria and so on. Those public pages, yeah, they may be generally accessible, but they're made generally accessible by, for example, the internet service provider. They're not made publicly accessible because the government they're being provided or set up by the government. Although I at some point I wouldn't mind talking about, there are interesting cases in general. Amy's right that we're not, most of the online stuff involves, Google, Facebook, Snapchat, whatever, but there are situations where governmental entities will set up pages on Facebook. And then, in effect, even though Facebook is a private entity, the Supreme Court hasn't really dealt with this question, but the courts generally have held that if, for example, the city of Los Angeles sets up a Facebook page and they're providing information about governmental services and so on that Facebook page, or the mayor of Los Angeles, and he advertises himself as the mayor, not a guy who happens to be the mayor, but this is his private page in which he's got pictures of his kids and so on, then there may be a situation where the First Amendment would prevent that governmental official or governmental entity from censoring comments that you make. So there can be all these weird kind of interactions between, including the president in his Twitter accounts in a case that's been recently litigated. So there's sort of this interesting confluence between what's private, Facebook is a private company, but then a governmental actor has set up a page on Facebook, and that may be subject to First Amendment constraints.
Well, we know from a recent judicial decision, the name escapes me, that public officials can't block you. So if you're commenting and you're writing all this terrible stuff, they're not permitted to block you because of this sort of, public forum within a private forum. Is sort of an interesting, theoretical construct, right? But I mean, to the broader question of whether or not these social media spaces are becoming traditional public forums, in the sense that they're replacing a park or replacing the street, especially in a pandemic context, that's sort of an interesting question. And I haven't seen that in the courts, but I do think that there is, there's something to that, given that the other avenues for expressive engagement with the community are lessening and lessening all the time, that there might be something to that, but that's not based in legal, jurisprudence. It's just my own take on how, it's applicable.
So right now, we're headed into an election. We've had months of protests for Black Lives Matters. Actually, today, the Breonna Taylor case had a decision, and there was a lot of social media activity about that today. General comments on police brutality, plus your run-of-the-mill just expressing yourself online to begin with. With all these opinions swirling online and people wanting to express themselves, are there certain things they need to be careful of, or certain things that have to be kept in mind while they're trying to express themselves on these platforms?
I mean, there's the broad, defamation concerns where you wouldn't be prevented from saying the thing, but you could get punished for it if you're saying something that's false and it's false as you say it, or you say it with reckless disregard for the truth. And it's something sort of terrible about someone. Case law sometimes uses the term moral opprobrium, which I always thought was funny. So there's those kinds of concerns. And then there's, if you're concerned about getting your account disabled or your posts taken down, there's those issues too, those community guidelines, terms of use problems that we've talked about. I know that in Instagram context, for example, a lot of artists have been censored, that the female nipple never will be seen on Instagram. It's a big problem that artists are constantly saying, my works are getting taken down, especially women. And Instagram has had a closed door meeting about it with different artists and actors in the space. Sort of ironic to have a closed door meeting about, free speech and, signing of an NDA and stuff. But that happened last year. So, you're really up against these issues of, general defamation. And then, are you violating the community guidelines of the platform that you're speaking on?
There are some, I think Amy's absolutely right that the most obvious thing to be concerned about, potentially be concerned about, is defamation. But there are also some other torts. Tort is basically just something where it's a dispute between private parties using the court system, but dispute between private parties of a wrong where there's no contractual obligations. But there is something called intentional infliction of emotional distress, that you see that sometimes used in cases where somebody alleges that somebody else's speech about them was just so so invasive of their privacy, so scurrilous, so harmful that they suffered severe emotional damage as a result. So it's not quite necessarily the same as falsity, which is sort of the key to defamation, but related. And I'm worried that we're going to confuse people with the whole overlay between the public and the private, even though at some level this is a dispute between, I say something nasty about Aimée, online, and she takes offense and sues me. That seems to be, and it's on Facebook, so there's no issue about it being the government. There is still a First Amendment overlay, because in a famous 1964 Supreme Court case, called New York Times versus Sullivan, the court said, look, if the court system is involved, and it was in that case, it was people in the South suing the New York Times for an advertisement that was sort of in favor of civil rights. And the judgment in the court in Alabama was this enormous, at that time, $1 million judgment, which was a huge amount of money. That the fear was, oh my God, people will use these private laws, defamation laws, but they'll use the court system and they'll bankrupt speakers, including newspapers. And the Supreme Court held that the First Amendment doesn't allow for simply liability to be imposed in many defamation cases based simply on falsity. There has to be more than that. And that what Aimée was referring to was what called falsity or reckless disregard for the truth. But you really have to prove it. And yet there's a heavy burden on the person who's saying they were defamed to show that the person who did this knew that it was false, or so blatantly disregarded all evidence that they should have known that it was false. So there are sort of constitutional protections for this speech online, or there can be if there's a defamation claim, even though the dispute is between the two private parties. And I'm worried I've made this much more confusing than it needs to be. But frankly, it's not. It is kind of confusing doctrinally.
I mean, it can be confusing. That's why there's entire attorneys that have their entire practice around this issue. There's two different areas I want to get into. I want to get into contracts and employer, and maybe the things that can get you in hot water, which again is not First Amendment at that point, because it's like a private contract with an employer. And then the other issue, which I know might be Aimée's specialty, is I want to talk about posting art online and how social media platforms might react to political art, or again, potentially offensive art, and things like that. So which area do we want to talk about first? We did get a question in, so I want to read that. How about that first? Could an intentional emotional distress injury be alleged against a person commenting on a post on Instagram or other social media platforms?
The annoying lawyer answer that's almost always the lawyer answer is, well, it depends. And that would be really, what exactly was said. And does it rise to the level of outrageousness such that a reasonable person, not you specifically, but, an average person that you pull from the street, would understand that to be so outrageous as to cause a harm? And so we're going to really be looking, and a court would really be looking at, I think, and and what actually was said there. So if it's and maybe the repetitive nature of the comments, or things like that might come into play as factors, but that would be my initial pass.
Yeah, I agree with that. Another obnoxious lawyer answer is, could you be sued? And the answer is, yeah, you can be sued for anything. The question is, are you likely to lose? Because unfortunately, people use the court system all the time to bring completely meritless suits. So I always try to make that clear to people that if you speak, yes, you could always be at risk for speaking, but the question is, are you at risk of really liability because what you're doing is a court could potentially find that it's not protected, for example, by the First Amendment, or it otherwise violates a legitimate law that can restrict speech.
Okay, so we had a question come in about posting art to one's own website. So let's move in first about posting art and censorship and what might happen there. CLA, we cover arts of all disciplines. So visual art might be the first thing we think of, but this could potentially apply to music or performances or other ways of capturing creative expression through your platforms. So the question that came in is about one's own website, which I would assume is not through a social media platform. So maybe we can think about it on both social media and other web domains.
So generally an ISP has what's called a safe harbor. So they're not going to be liable for what you post on your own content. And so social media companies also would fall within that, it's as far as I understand. So you would potentially, if the artwork is not your own, even if you post it to your own website, you could run into what's called a Dmca takedown notice. And this is really in copyright law, but it's actually an interesting, overlap with First Amendment rights because normally you can say anything you want, but you might get in trouble later, right? But nobody can stop you from saying it in the first instance. And if they stop you from saying it in the first instance, then that's what's called a prior restraint, and it's frowned upon greatly.
For your information, the Supreme Court has roundly rejected prior restraint.
This is not a First Amendment thing.
So maybe if you publish troop movements or something, you might be able to be, shut down right away. But otherwise, but a big exception to that is the Copyright Act, where injunctions are granted, fairly routinely, I would say. And the Digital Millennium Copyright Act, which gives us the DMCA, that acronym, provides for a removal notice system. So if you post something that someone says is their artwork, like if you're talking about artwork that's not your own, that you're posting online, that somebody else is claiming a copyright interest in, they can, use the DMCA to take down that material by, notifying your ISP. And then they'll remove the work, tell you about it. But in the meantime, your art is gone from the internet or the artwork that you posted. And so, if you do a lot of appropriation art where you're incorporating copyrighted materials, things like that, it might be a problem. So in terms of your ISP, you would have to be worried about a DMCA takedown notice if your work is not original in any way and could be subject to a copyright claim. If it's your own work, unless it's, obscenity or, could fall into the restrictions on, distribution of child pornography or something like that, that would be government interference would be able to take that down as far as I understand it. But otherwise, I think that what you post would be yours and would be okay.
Yes, and if you post your art online and you find other people are taking it and reproducing it, that copyright takedown can be something that you utilize to protect yourself, right?
Certainly. Especially if you register it and you get that registration number, that always is helpful. But yeah, the DMCA it's a powerful force for stopping content. There was a case out of California regarding Prince's, I can't remember the song, but it was a woman in her kitchen and she's filming her child dancing to a Prince song. Okay, and so this was just the dancing baby case, sort of, and it was a couple of years ago now, maybe 2016, and it addressed that issue. Could the Prince estate shut this down, or could this woman's video remain on YouTube? And she was upset about it, and she took it pretty far. If memory serves, she got to the Ninth Circuit and she won. And we learned that when you file a takedown notice, a DMCA takedown notice, and you submit one to the ISP, you have to declare that you really believe that someone's violating your copyright and that they have no other basis to claim a right to do that, to put that work online. So there's no fair use at issue or something like that. And so that's the first time that we saw that there was, really teeth to these declaration provisions that are within the DMCA notice procedure.
Can I jump off on it just for a second? It takes it beyond the realm of art and copyright, but Amy alluded to this safe harbor. And that safe harbor, maybe there's a specific one for trademark and copyright, but in general, internet service providers are protected under the Communications Decency Act from basically if they cannot be treated the way a newspaper publisher can be treated. So for example, if a newspaper publisher runs an op-ed from somebody and there's something defamatory in that op-ed, the newspaper publisher, not only the person who wrote the op-ed, but the newspaper publisher can be held liable for defamation. That's not true for an internet service provider. If I post on Facebook something that is defamatory, Facebook really has no obligation legally, forget moral questions, but legally to police and say, oh my gosh, we're going to check and make sure that this statement that Peter Eliasberg has put on this Facebook page is accurate or not. So the internet service providers have a substantial amount of protection. Now, this is particularly kind of a hot button issue because Trump has been making a big deal about this. He's upset that Twitter, for example, has put comments, and part of that protection is also their ability to restrict speech if they find for any reason they find it offensive, they find it false. So they sort of have no obligation to police the speech, but they're also protected if they do choose to police the speech. And Trump has at least made noises about trying to get Congress to change the Communications Decency Act. But at least for now, the internet service providers are basically free to decide, that they're not going to police speech that's on their sites, or that they are going to make efforts to police it because using, let's say, community guidelines.
And someone put in the chat kind of a follow-up. These things you're talking about, defamation, that's only for private individuals, right? It doesn't affect government or public individuals?
No, a government official could sue for defamation. Sort of considered bad form, but Trump does it all the time. But in general, I think it's happening more and more. Devin Nunes has done it a bunch of times, usually lost because the speech is so obviously not even a statement of fact about him. It couldn't possibly be considered defamatory, but he's done it. But no, a government official can sue for defamation, and they do.
I think the primary distinction in the law on this point isn't so much a public official, so much as a public personality, a person who's known to others generally, sort of like this, that person has a higher burden than a private person who nobody knows about, but for this like horrible thing that you happen to say.
So both of them can have defamation, but yeah, the more well-known and the higher status you have, gets harder and harder to win those cases, especially if you've been in the press a lot yourself already. And moving on again, so because a lot of our community is artists, we have a lot of people signing freelance contracts or even just like they have agreements with their employer. I wanted to go over, there are different types of clauses that have started to appear in contracts that kind of protect the employer from a private employee voicing their own opinion. So I've seen personally morality clause, and I've seen indemnity clause, and then there's non-disclosure agreement, which is a bit different, but kind of in this realm. Would you guys mind explaining what those things mean and what constitutes as violating them?
Well, I'll take one. Aimee can do another. An indemnity clause is generally just, in effect, saying, look, if you, the employee, although you can have indemnity clauses in a variety of different circumstances, but if you, the employee, do something, speak in a certain way, and somehow or other someone comes after us, the employer, for it, you agree that you will hold us harmless, that you, in some cases, will pay for any legal defense that we have to mount for your action. There are some, and I am not an expert in these clauses. That's the general definition of an indemnity clause. I'm going to go out a little bit on a limb and say I'm not an expert. It's my understanding, though, that generally for indemnity clauses to be enforceable, you have to have, in the end, you have to show that the person who is agreeing to do the indemnity did something wrong. So that it's not clear to me that if, for example, I say something, for some reason I get sued and my employer gets sued also, that if I actually had every right to speak in the way I spoke and the suit against me is meritless and the suit against the employer is meritless, that I really do have to cover the employer's costs, that in fact you have to sort of show that you did something wrong in order for the indemnity clause to be triggered. But I'm not positive of that. But I do know that the indemnity clause basically says, look, you're agreeing that if you do a certain thing and we may have to pay for it, you're agreeing that you're going to cover our costs.
Yeah, I mean, and keep in mind that breaching the contract could be doing that thing that's wrong, right? So if you have a very broad morality clause coupled with an indemnity clause, you might run into this problem. In terms of morality clauses, I mean, you would have to look at the language that's actually included in the document to really know what you can't do. But it's generally a way for a company who has a strong brand. Like, so let's say you're doing a commercial, you're shooting a commercial, or you're the subject in something where the company has a really big, like sort of family value sense, and being associated with pornography might be devastating to them more so than another company, let's say. Right, that company might be very interested in including a morality clause so that you understand that you're on notice, that you're, for the time that you're operating within this agreement, that you need to be holding yourself out as a very, moral person, in accordance with whatever the restrictions are that are included in the agreement. It could be, agreeing not to use their mark, their trademark or logo in a manner that, in association with something that they might find untoward, or it could be, not speaking at all. It's really, it could be broad or narrow depending on the drafter. But they are something to definitely look out for if you see that. And if you don't understand what you're not supposed to be doing, or you think that it's broad enough to cover a wide range of behavior, then that would be something that maybe you would want to push back on if you have the leverage or bargaining power to do so. An NDA is just sort of a standard, usually standalone agreement that prohibits your ability to say anything about whatever the topic of the NDA is. So in idea submission cases, they happen in Hollywood a lot. Copyright law is not going to protect your idea for your screenplay. It's going to protect the language of your screenplay, but it's not going to protect your idea. So in order to cover that, contract law comes in with the non-disclosure agreement to sort of try to protect you in that sense. And companies use that too. I alluded to it earlier. Instagram had all of their participants at their closed door meeting about, censorship and art on their platform. They had all the artists sign an NDA. One of them decided that she didn't want to do that. She didn't go, and she, provided a public statement that I think was read into the record as far as news reports about that meeting went. But that's an example of where the subject of the NDA was the meeting itself. The subject of the NDA could be your screenplay idea. It could be, your intellectual property that you created. It could be your logo designs, or who knows what it is. But in the context of an employer, it's definitely going to be stuff like trade secrets, which could be customer lists, or, different kinds of materials that a company might have that they believe is proprietary. You would definitely, see NDAs in those contexts.
From my experience in writing and journalism, because things like Twitter might be such a big part of like your personality and your voice, these clauses have been appearing a bit more often in these freelance contracts than they used to. And I don't know if that's affecting other industries as well, but people have been noticing, like Hearst added these clauses only very recently into freelance contracts, and Condé Nast as well, because you might tweet something and it might be a tasteless joke or something, but then they don't want to be associated with like the joke, or like you might, criticize Trump or something, and people are like, oh no, like we don't hold that value, so you're independent as a writer, and our magazine doesn't necessarily like endorse that. So, and people working in the entertainment industry all the time will be signing NDAs, and theoretically you're not supposed to mention anything covered over that. So I would suggest, if you signed a contract lately, I'm sure you read it, but just in case, go through it and see if any of those things are affecting you. It's hopefully unlikely that it would be acted upon, but one thing I wanted to think about was, I think with social media, especially now, people are going viral and they're not maybe intending for their statements to see such a big audience, or maybe it's a video they put on TikTok and it somehow like blows up, as people say. If you go viral, like how can, like, is there any kind of aspect of First Amendment or censorship or, defamation that kind of like might come out from those things? Sometimes people are going viral because it's like enjoyable, but sometimes they might say something that is a lot of people don't like, and so they suddenly get a lot of criticism. How should people deal with the thought of going viral, or like the consequences of that, both either good or bad?
Well, I take one little piece of that. In the defamation context, all that's necessary, or one of the elements of defamation, is what they call a quote publication. And that can be nothing more than me telling one other person, or it going viral and being something that's where there are 50 million hits. But if it goes viral, the damages, if a defamation claim is brought against you and the plaintiff wins, the damages are going to be astronomical for something that went viral. It's going to be much harder to say that your damages were very substantial if what you say is, hey, you told your next door neighbor that X, Y, and Z about me, it wasn't true, and you met the other elements of defamation. So I mean, I had to be overly cautious, but I would say that if you're posting stuff online, I think you have to be aware that it may go big, and you shouldn't just presume, oh gosh, well this is going to be no big deal because I'm just posting it in this relatively obscure place and I don't think anyone's going to hear about it. Well, that may very well be the truth, but it could not be the truth. So I think you have to be aware of the risk. And the second thing is, if you just say it to your neighbor and the neighbor it never gets back to the person who might claim to be defamed, they're never going to know and they're never going to bring a case. The instant it goes viral, it's not going to be very hard for them. They're going to know, and then they're going to have a basis to be aware that there's potentially a lawsuit to be brought. So I guess those are two things I'd say about the consequences of something going viral, or at least anticipating the possibility that it might.
Yeah, I don't have much more to add other than every time I write anything down, whether it's even in an email or a social media post, I think about, what it would look like if it went further than my intended audience, because I know that that's a very real possibility, but I'm also an attorney, which probably makes me risk averse. But I do think that that's in a sense, it's a shame that damages could be so devastating, because it really does, create a sort of chilling effect in terms of what you want to say, just like morality clauses do. And, more generally, the fear of harassment, saying something online, I think all of those things really do maybe make people think twice, and we maybe we don't get the viewpoints that we might want to hear because of these sorts of concerns. And that's not really something that the law is going to address, but it is something that's out there that happens.
I wanted to go back to a question that is in our Q&A tab. We have this one about municipalities are trying to be sensitive to things like Black Lives Matters in support of the movement, but of course there's also the opposite perspective where people might be posting Blue Lives Matters or criticisms of it. How do the municipalities cater to both viewpoints or push back against maybe the ones they don't agree with without running afoul of the First Amendment? And should a municipality have an official stance or an official statement on such a big movement like this?
Peter, that seems like it's in your wheelhouse in terms of the viewpoint discrimination issue. So I
sure, I'll take it on, but this once again, I had a friend of mine who's a very good lawyer, but has done a lot of complicated cases, but doesn't do a lot of First Amendment work. He's always telling me, oh my God, the doctrine is it's so unbelievably these sort of tests on tests and this whole complicated scaffolding of different doctrine. He thinks it's, oftentimes makes no sense. And at some level he's right, but we nonetheless have to try to make sense of it. So this gets very complicated. So let me make a couple of points. First of all, although it's not really clear whether government entities are protected by the First Amendment. It's generally accepted that government entities can be speakers and could, for example, say, we stand for, the City Council of Los Angeles could put out a resolution saying, we stand with Black Lives Matter. And they can do that and not be deemed to be acting as a speaker and not deemed to be not required to in effect give equal time. They do not also have to pass a resolution that says we support the police, and we believe that they generally behave very well in their interactions with African American men on the streets. They can take a position that's on one side of the sort of political debate. And they're really not only they may have a right to do so under the First Amendment, but you, the person who wants them to put out the Blue Lives Matter statement because you're upset when they put out the statement in support of BLM, you're not going to succeed if you go to court and say, gosh darn it, I asked them to put out the Blue Lives Matter resolution and they didn't do it. The court will say they're allowed to have a public position on a controversial issue, and they're allowed to have a public position that's on one side of the equation. So having said that, it's an entirely different thing when the issue becomes, well, do they have to allow Blue Lives Matter parades or protests and Black Lives Matter protests? And the answer is they have to allow both. They can't say, well, we're officially on record of supporting, being very supportive of Black Lives Matter, and we're critical of the way the police, let's take the city of Minneapolis, which say, we're going to reconfigure and sort of try to get rid of our police department. So we're clearly on one side of the equation. We're with Black Lives Matter, very critical of the police. But the police union wants to hold a protest against the potential that the city is going to defund the police department. The city cannot say, well, we're favor one side of the equation, so we're going to create differential access to parade permits or protest permits or whatever. They have to be even-handed. They cannot make distinctions based on the content or the viewpoint expressed. The trickiest area would seem to me when the city says it's not clear that the city itself is speaking. So the city council does not put out the resolution, but it sort of says we want to put on a Black Lives Matter art display. But we're going to be very clear that we're going to curate it and we're going to make sure that the content is that which we like. They can probably do that, but it gets a little tricky. The more they're not crystal clear about this is the message we're getting across and we're keeping out, this is our expression, as opposed to an opportunity for artists to express themselves generally on a particular topic or subject. They probably can do that. But the minute they say we're going to have an art show about social upheaval protests in the 21st century, they probably cannot, almost certainly cannot, when that's what they say they're going to do, say we're only going to take art that we see as sort of in favor of or siding with Black Lives Matter, but not siding with a point of view that might be more supportive of the police and more critical of protesters. But when you get to that area, the boundaries get a little bit more, it's a little trickier. But I think it's very clear that the government can have its own viewpoint and express its own viewpoint and not require the opposing viewpoints. They have to allow the opposing viewpoints on the street and in parades, but they themselves can't be forced to express those opposing viewpoints. But as I said, it gets trickier if they open up sort of the art show generally on a particular subject. But then, actually, let me be a little clearer. If they open an art show on a particular subject, protest in the 21st century, they cannot say, in effect, but we're only going to allow stuff that we think favors Black Lives Matter and not stuff that's critical of Black Lives Matter. It's a bit of a mess, though. I get complicated fact scenarios where people come to me and I'm not quite sure what box to put it in when I see the facts as presented to me.
Sometimes those discussions and those one view, counter view, they get pretty heated. What is like the litmus test, or what is like, when does something cross the line and go into harassment or even more extreme into like hate speech? Or how do attorneys or how do moderators decide on what is like too far?
I think the Supreme Court has been grappling with some of those questions for a long time. And in an online context, fortunately or unfortunately, you have a situation where a company is creating a policy. And so they're not, it seems, I read through before this panel, I was reading through Facebook, Instagram's community guidelines, and they have a definition of hate speech. They have a definition of what they consider a violent threat that's going to get your post removed, etc. But it is really discretionary with whoever's reading your post and making that determination. And discretion is something that in my understanding, and I'm not a First Amendment attorney, it just comes into my universe because I help a lot of artists, but it does seem like discretion is something that we don't want to have an official to have. It's like the person who's doing the censoring, if the more discretion they have, the more their bias is going to come in to decide what gets heard and what doesn't, and what gets shut down. And so in terms of those hard questions, the courts have grappled with them. And, I'm most familiar with the issues surrounding what constitutes obscenity as opposed to what constitutes hate speech, and there, if we're only allowed to call something obscene and shut it down, like, Mapplethorpe's exhibition at the Corcoran in Washington, D.C., right? Like, that was a big, big hubbub. Everybody wanted to shut it down, right? I think that it traveled to Ohio and the curator was arrested, right? And so in those situations, what's constituting obscenity? Could we really say that Mapplethorpe's photographs are devoid of any artistic merit or scientific value, or those are the kinds of standards that we're getting from the court. In terms of the hate speech standard, I don't actually recall it right now in this moment. It's been a minute since I was in constitutional law where this was coming up, but I do know that the court or a court wouldn't be making that determination in an online context. It would be whoever's viewing the post, that employee of that company, and, trying to adhere to this community standards policy as best they can.
So let me jump in on the hate. Amy, the reason you don't know what the First Amendment standard is because hate speech has no true legal meaning in the First Amendment.
Okay.
Hate speech is not unprotected. There are certain categories of speech. When I say unprotected, it means the government can restrict them without running afoul of the First Amendment. Obscenity is one of those categories. Incitement to imminent lawless action is another one. And then there are so-called fighting words, which are basically words that are so likely to provoke an immediate violent response that's also a form of speech that the government can prohibit. But none of those, what a lot of people consider to be hate speech, really offensive, hurtful, harmful comments about people based on their race or their sexual orientation or whatever, in general, are not, you may call them hate speech, but they are not, the government cannot prescribe them consistent with the First Amendment. In some very small category, some of them might be considered incitement to imminent lawless action, or if delivered in a particular way, in a heated face-to-face discussion on the street, I could say something to somebody where it could be deemed to be fighting words.
Hey, you, let's fight. Them's fighting words.
Where it really couldn't be if I did it online, because how is the person who receives that, a day later in a different part of the world going to say, well, I was going to go hit Peter for posting it online? It's literally physically impossible to do. So hate speech is not unprotected by the First Amendment, but I do think that it is a term that comes up in some of these policies from the service providers, or they are restricting more speech than the government can restrict consistent with the First Amendment.
I think that's certainly true. And I guess we'd have to go and see about incitement, right? That would probably be the closest. Burning crosses, was that? Because I know that that's not protected speech.
No, actually, even that maybe depends on the context.
Yeah.
I do that in my own backyard. Probably, again, I'm being descriptive here. I'm not stating normatively what I think necessarily it should be, or whether anyone, just my saying something's protected by the First Amendment doesn't mean I'm endorsing it in any way, shape, or form. But I do it in my backyard. I burn a cross. Hateful as it is, it probably can't be restricted consistent with the First Amendment.
So these are really high bars and really difficult to achieve at some point. So now that a lot of meetings are happening online because, the pandemic has, I know actually, because I also work for the city of Los Angeles, we're not allowed to have public large gatherings right now. So city council and all that stuff is on Zoom right now. But people who don't have access to technology might be considering that censorship. Is lack of access to government, is that a First Amendment issue?
It can be. And a classic example is access to court proceedings. Attempts to hold closed court proceedings, except in very unusual circumstances, are generally violate the First Amendment. It's a really interesting question. I don't have a very good answer, because I don't know that the fact that somebody may say, well, gee, I want to participate in this meeting, but I can't because I don't have internet access, would have a valid claim. Because when we were holding in-person meetings, there were all sorts of reasons that people could say, I can't attend in-person meetings. That run the gamut from, why does the County of Los Angeles hold their Board of Supervisors meetings at 9 o'clock and 10 o'clock on a Tuesday, when most people say, I can't attend, I go to work, and then they drag on so long in the first hour of them is sort of all this ceremonial fluff. So people say, I don't even know, I can't set aside my whole day to go to these meetings and make my public comment. So I'm not sure. I think the reality is that the courts would say that no government meeting, there's a guarantee that everybody in every circumstance is going to have an access. And it's unfortunate that you can't access, but I was going to say you could go to the public library and access the internet, but of course now with COVID we can't. But I'm not sure that there would be a valid claim there. I mean, it's an interesting idea. But one thing you should know is that in some cases, for example, in California, access to public meetings is also protected by statute. There's the so-called Brown Act. And we have actually we've written letters to a lot of governmental entities that, for example, they're holding their meetings through teleconference or video conference, and they're not allowing public comment through anything other than emails submitted the day before. And we've argued that, in effect, you have to, if you're holding a Zoom meeting, then you have to use the Zoom capability that allows people to queue up and raise their hand and make public comment there. And we haven't brought a lawsuit on it, but we have succeeded in persuading most of the government entities that we've written to to change their practice and allow not only online commenting or email commenting, but also making them change so that people can participate by Zoom and make public comment by Zoom.
I'll just add on to that with your starting point with the court proceedings. It was my recollection that, because there was limited seats in a courtroom, right? Not everybody could attend, even if you wanted to attend. So in terms of access, it was often, the spots would be given to the press or people who would be able to disseminate the information. And that was seemingly okay if there was, too few spots for people. So in the Zoom context, if you're able to have an advocate, if the press is able to attend, if you're able to get the information that was provided in this other context and it's not actually closed, then maybe you wouldn't have a claim either.
Although I think that's right. Although, my understanding, and I'm not terribly good with all these technologies, but I think for minimum or no cost, you can have pretty much an unlimited participation Zoom meeting.
Sure. I was thinking more like recording and send somebody a DVD or something like that, where you could get the information. You just wouldn't participate in real time, but that wouldn't necessarily be, a prohibition that the court could come and fix.
Well, I know that people, when I talk to attorneys, the internet is like a wild west. New technology means that there wasn't a lot of previous legislation to give people decisions. So one person asked, do you think that legislation could ever be enacted that would extend a judicial arm into the discretion of posts online? Would there ever be a public-private crossover with regulation? And I see they were calling out especially hate speech and untruths posted online, and definitely fake news, and this whole category is really big right now. So should our government regulate those kind of possibly disinformation and mean and hateful messaging?
There are a lot of questions in that one question. At some level, you could say that the government already regulates a little bit of that by prohibiting defamation. There's certainly some place where the courts could rule on whether a comment made online is defamatory and could subject the speaker to penalties. As Aimée previously said, probably not an injunction requiring it to be taken down, but damages for having done it. Could courts be deemed, and I actually want to throw to Aimée the question of, are courts now ever, if there's a dispute between a poster who gets his or her stuff taken down because Facebook says it violates their community standards, are there any cases in which courts are actually interpret and saying, well, no, actually, we don't believe that post did violate the standards as written, and therefore you have some kind of recourse against Facebook?
I haven't seen that, no, but I haven't looked either. I think it would be an interesting avenue to pursue. I've seen lawsuits against Facebook, but only in the context of using somebody, in an advertising capacity when they weren't aware that they were, being used in that way. But otherwise, I haven't seen a dispute over community guidelines or, their discretionary capabilities in terms of shutting stuff down. I know that on a practical level, people have definitely petitioned Instagram and Facebook, artists in particular, because of these nudity provisions, because of the ability to shut something down. More recently, there's a new algorithm that Facebook and Instagram employ, maybe Twitter as well, but artists have been complaining about it in the Instagram context, just because Instagram is just such a platform for artists, where the algorithm will find digitally manipulated material and put a warning over your image so that you can't see it. So digital artists' works are being restricted from view, and so your posts will be downgraded, and you won't see as many of it, as big of an audience as you might otherwise, because you're using digitally manipulated media. But that's the point of the work in these particular contexts. So I know that artists who work in digital mediums, artists who use a lot of the human form, have been petitioning Instagram and have had meetings with them in order to get them to change their policies. But I haven't seen any policy change. But it seems like it's been much more in the private actor realm than in the judicial recourse realm. I haven't seen a case.
Somebody wanted a clarification on the First Amendment protections for the press. And is there a difference at all between traditional print and publications that are doing all the digital version of their publications now?
Not generally in terms of the First Amendment, but this is a place where in some circumstances, this is the provision I referred to earlier, the Communications Decency Act. If for example, the LA Times sets up kind of a forum online that they don't really moderate, for example, allowing all sorts of comments on a particular article, that would probably be a place where they couldn't be held responsible for the comments made in that forum. But if they're just running the letters to the editor that are in their print edition, where they are exercising, they're actually acting as a true, they're not saying, hey, look, this is just a forum, everybody can jump in and speak, and we're not going to pretend that we're policing it. But they are actually saying, these are the letters to the editor that show up, that are in our print version, where they clearly do exercise editorial control. I sent in many letters to the editor that didn't get published. They clearly would say that some stuff they think is garbage and they're not going to publish it. So they do exercise a variety of editorial control. In those circumstances, I think they could be held liable for defamation in a letter to the editor. But I don't think they could with respect to if they set up this sort of online forum and they're just allowing, it's the Wild West, and they're basically allowing people to all sorts of comments and they don't purport to be moderating it. So a bit of an odd distinction, and it's not a First Amendment distinction. It's a distinction based on the Section 230 of the Communications Decency Act, which gives this protection to these internet service providers and others who are kind of are setting up these online bulletin boards and other things.
So we're going to wrap up now. So I just want to say thank you, Amy and Peter, for your time and expertise. And thanks everybody who's still here for joining California Lawyers for the Arts tonight.